And it was just, I mean, what an oddity that story would be picked up by the press, that if you didn't pay your lunch money, that your kid could go into state care because that was evidence that you couldn't feed your children. And then a Pennsylvania businessman stepped up and he says, look, I'll pay the $22,000. Don't threaten to take children away. And then there was like, oh no, you can't do that. That's not good enough. And then all of a sudden they're in trouble for it. I mean, and Pennsylvania is a really, really bad state. So that one little story, and that's such an odd little story, it's kind of like an odd little meaningless story. Somehow, some way, somebody got that story to the press. And that's part of what is so important about reform, is having the press understand what the issues are and work with them. As you know, I've already said that you all know about the criminal charges they brought against me and the district attorney's trying to gag me. But, I mean, the thing that she doesn't have any evidence. She's like claiming it would cause a public outcry. She's like saying that it could cause a disruption. I'm like, look, I've spoken in all kinds of forums. I've been in political forums. I've been at the Indigent Task Force. I've been at the Board of Judicial Conduct. I've been in legislative hearings. I've met state and federal legislators, and nobody has ever accused me of disrupting a meeting or disrupting a proceeding, ever. So it's just a fake charge, and they need to forget it. All right, now, one of the reasons I really just wanted to just do a flash video today and talk to you is there have been several cases that have come out that I keep my eye on, federal cases that are coming out all the time related to constitutional rights, particularly First Amendment, Fourth Amendment, Eighth Amendment, Ninth Amendment, and 14th Amendment. So the First Amendment, as you all know, is the right to freedom of speech, freedom to assemble, freedom of association, right? The Fourth Amendment is unlawful search and seizure, which expands to coming on your property, pinging your phones. I'm going to talk about that in a second. The Eighth Amendment is very important because the Eighth Amendment is for unusual punishment, toxic conditions of confinement. There's been court hearings that have held that people who are in mental institutions have a right to be free of toxic conditions of confinement. And the same goes for our foster children. So we need to push that and protect our children who are being put in these abusive foster situations, basically. And then the Ninth Amendment is an unusual amendment, but it's one of the first 10 amendments, and it basically says something like, just because we don't name an individual right here specifically doesn't mean that it doesn't continue to exist. So I haven't really dug in and studied that amendment, but it's a very important one to cover parental rights, right to make medical decisions, etc. The 14th Amendment is the rights of privacy interest, basically saying that the privacy interest also apply to individuals. So the due process, it's a due process amendment for substantive and procedural due process. It's our right of privacy to family and familial association, etc. Rights of individual privacy, which I'm going to be using for fake Amber Alerts in a lawsuit. And I'm going to tell you a little bit more after that, right after it gets filed. Okay, so this is so interesting though. I knew it was going to happen. I watch federal court cases all the time, and I just know, sometimes I can just feel something's got to happen on this particular issue, and we just have to keep watching and keep our eyes open. So we get, for the Sixth Circuit, there's like a weekly update on certain things, new cases that are coming out from the Tennessee and the Sixth Circuit. So this case is called Novak v. City of Parma. It's out of Ohio. So I'm in, Tennessee's in the Sixth Circuit, which is, where's Connie? So Tennessee's in the Sixth Circuit, which is Tennessee, Kentucky, Ohio, and Michigan. It skips Indiana. Indiana's over with Illinois in the Seventh Circuit. So those are our four states. Those are all the federal case laws that I watch all the time. Ohio is a hopping place, boy. I mean, there are so many constitutional violations in Ohio. I know we got a lot of Ohio people out there, but there are always cases popping open in the Sixth Circuit from Ohio. So this case is from Ohio, and it's about Facebook, okay? It's about First Amendment and Facebook, y'all. It sure is. All right, let me tell you this story. This is so hilarious. Okay, here's how the court opinion starts. Listen to this. Apple pie, baseball, and the right to ridicule the government each holds an important place in American history and tradition. So thought Anthony Novak when he created a Facebook page to mock the Parma Police Department. He styled his page to look like the department's official Facebook page, but the similarities ended there. Novak shared posts like an advertisement for a pedophile reform event. Sorry, but that's what it says. At which pedophiles would receive honorary police commissions. All right, of course, he's being pretty aggressive. Novak's page delighted, disgusted, and confused. Not everyone understood it, but when it comes to parody, the law requires a reasonable reader standard, not a most gullible person on Facebook standard. Right? Did you get that? Let me read that again. When it comes to parody, the law requires a reasonable reader standard and not a most gullible person on Facebook standard. The First Amendment does not depend on whether everyone is in on the joke. Neither is it bothered by public disapproval, whether tepid or red hot. Okay? Novak's Facebook page was either a protected parody in the great American tradition of ridiculing the government or a disruptive violation of state law. Maybe both. At this stage, we only decide whether or not the officers are entitled to qualified immunity. For some of Novak's claims, they are, but for others, they are not, is going to be their summation. All right, now, let me just tell you a little bit about this case as far as the legal stage. Whenever you file a civil rights suit and you file against any individual for violating your civil rights, one of the hurdles you have to go through is called qualified immunity. Every single person who's a state actor gets this shot at qualified immunity. And basically, I mean, it's so disgusting, but basically it says that only really the dumbest of the dumb about your constitutional rights should be charged with the offense, right? So it's saying if we've not already established that that specific thing is a violation of your constitutional rights, they get a free ride. They get a free ticket. They get off the hook. All right, but let me go on and tell you in this case what they did. Okay, so Novak created a farcical Facebook account designed to look like the police department's official page. Among the posts was a recruitment advertisement that strongly encouraged minorities not to apply. Novak also posted an apology from the department for neglecting to inform the public about an armed white male who robbed the Subway sandwich shop while promising to bring justice to an African American woman who was loitering outside the Subway during the robbery. So obviously they were just doing everything they could to impugn the actions of the police department and make them look like fools. The page was polarizing. Some of its 100 followers, they just have 100 followers. I mean, we have like 12,000. Some of its 100 followers thought it was the funniest thing ever. Others were angry. And yet others were confused, wondering whether this was an actual Parma police official Facebook page. A handful of people were so angry or confused that they called the police station. In all, police received 12 minutes of calls. Others continued to enjoy the page, which soon became a platform for a wide range of citizens to air their grievance about the department. Oh, really? Okay, is that anything like what we do, right? We are there. Family Forward Project is, sometimes we're just there to air our grievances about what's going on with child welfare. The officers later testified that they worried the page would confuse the public and that the likely result is that people would call. One of the page's audiences, the Parma Police Department, did not find the page funny. Okay, does this sound like anybody we know? I mean, y'all, if you've been part of Family Forward Project for a while, you know exactly what I'm talking about. People who do not find it funny, okay? One of the officers got wind of Novak's page, and they all stopped what they were doing to take a look at it, and a couple of them tried to figure out who did it. One officer said they just wanted it down, and they took several steps to make that happen. Listen to what they did. A Facebook battle ensued. First, the department posted a warning on its official Facebook page. The warning alerted the public to the fake page and assured them that the matter was currently being investigated. Yeah. Then Novak reposted the exact same warning on his own page. He claims he did this to deepen the satire. For the same reason, Novak deleted pandemic comments on his page explaining that the page was fake, as these clumsy explications only belabored the joke. After that, the conflict moved offline into the real world. Officer Connie Reguli assigned Officer Thomas Connor to the case and tasked him with finding out who ran the page. So Connor sent a letter to Facebook requesting that the page be shut down immediately. He also sent an email to a different Facebook representative asking that the page be taken down. The police also informed the local news outlets of the investigation. The case of the fake police page even appeared on the nightly news. Okay? Really, honestly. They were pushing this. At that point, Novak decided to delete his creation. He had heard of the department's investigation and was worried about the consequences, right? Who does this sound like, you all? I mean, all you know, we're all facing retaliation for First Amendment, it seems like. Although Novak was done posting, the police department was not done investigating. They still wanted to find the person behind the laptop. So Connor, the police officer, subpoenaed records from Facebook. Reguli directed Connor to go further and obtain a search warrant for Facebook. I mean, these guys were relentless. Novak, hang on, alleges that Connor made several material misrepresentations and omissions to obtain the warrant. The warrant still issued, and Facebook disclosed that Novak was the one behind the fake account. Once the department realized that Novak was the cyber culprit, Reguli directed Connor, these are the police officers, to obtain 2 more warrants. One to search Novak's apartment, and one to arrest him. The warrant said that Novak unlawfully impaired the department's functions in violation of an Ohio code. Novak responds that, other than 12 minutes of phone calls to the department, the police suffered no disruption in its functions. And Novak claims that the officers were unaware of the 12-minute call time when they obtained the warrants. But once again, the warrant still issued, and the department arrested Novak. The case went to trial, and Novak was acquitted. After he was acquitted of the criminal charge, he sued the city of Parma and the officers. He alleged in over 30 claims that the city and its officers violated his constitutional and statutory rights under federal and Ohio law. The defendants moved to dismiss his claims, and the court granted the motion in part, and 26 claims remain standing. So he filed 30-plus claims, and 26 of those claims survived the motion to dismiss. And so that goes on to talk about qualified immunity. So it talks about qualified immunity needs to be clearly established. And at some point, I'll just have to get into that more with you, just the real legal nitty gritty on that. Okay, let me go on here. All right, so there's a section here about retaliation. So under retaliation, it says Novak argues that the officers retaliated against him because of his protected speech. The retaliation claim turns on two issues: whether Novak's Facebook page was a parody, and number two, whether the Parma police had probable cause to arrest him for his Facebook page. All right, so let me go on. Let me skip a page here. This is really long. Of course, I can't read the whole thing. I've read it. It's very interesting, but... All right, now to allege a retaliation claim, Novak must show that, number one, he engaged in a constitutionally protected activity. Number two, the officer's adverse actions caused Novak to suffer an injury that would likely chill a person of ordinary firmness from continuing that activity. And three, the officers were motivated, at least in part, by the exercise of his constitutional rights. Now, this is really important. First Amendment retaliation civil rights claims are very important under today's environment. First Amendment retaliation. What is First Amendment retaliation? Number one is that you engage in protected speech. Protected speech can be political speech, criticizing your government, talking about government being incompetent, as long as you don't make false statements about a person individually. In other words, you cannot say, I saw Representative Smith drunk flat on his face with a hooker on 5th Street last night, right? You cannot say that because that is a factually false statement. However, if you say, I think and I'm just making this name up, y'all, this is not an association to anybody, but if you would say Representative Smith I just think he's a drunk and he doesn't know, he's out of his mind, okay, that's protected speech. That's politically protected speech, okay? So for First Amendment retaliation, civil rights claim, first of all, it has to be focused on a freedom of a political activity, politically speaking out, criticizing your government, being a political activist. Number two, the action that officials take against you, this is the key thing. The action that they take against you, they threaten to arrest you, they threaten to take your children, they do take your children, they won't bring your children home, they hold your children in foster care beyond when they really should. That is that you are suffering an injury that would likely chill a person of ordinary firmness from continuing the activity. In other words, if they say, if you'll shut up and not go on Facebook anymore, we'll give you your kids back. Or if they say, we're not giving your kids back because you will not continue, you continue to talk about us on Facebook, or you continue to say bad things. Those are First Amendment retaliation civil rights claims. And then the third part is that the people who did that action were motivated by your exercise of your constitutional right to free speech, okay? This is an important civil rights claim for parents, because I see over and over and over in Family Forward that they are being retaliated against because they speak out and they want to tell their story. Parents have the right to tell their story. They have a right to criticize those who are in the public specter, okay? You have a right to criticize those in the public specter. Then it talks about a parody. It says, was Novak's speech protected? The Supreme Court has repeatedly reminded us that almost all speech is protected other than a few limited areas. The limited areas include speech expressed as part of a crime, obscene expression, incitement, or fraud. It is clearly established, though, that parody does not fall into one of those limited areas. So the question then is, was his page a parody? The officers claimed that his Facebook page was false and meant to mislead the public, not a parody. But they were wrong to think that we just look at a few confused people to determine if the page is a protected parody. Our nation's long-held First Amendment protection for parody does not rise and fall with whether a few people are confused. Instead, we must apply a reasonable reader test. Speech that could not reasonably have been interpreted as stating actual facts is a parody, even if patently offensive. The test is not whether one person or even 10 people or even 100 people are confused by Novak's page. Indeed, the genius of parody is that it comes close enough to reality to spark a moment of doubt in the reader's mind before she realizes it's a joke. Okay, I'm just going to say this. There was some GIFs posted on, and you know how GIFs are. GIFs, GIF, actions, little scenario actions are always a parody, okay? It's always a joke. And so people who take offense about a little GIF posted and they're in public office, that's a parody. All right, let me go on. The germ of parody lies in the definition of the Greek, blah, blah, blah. I'm not going to read all that to you. Okay, so let me go on here. He goes on to talk specifically about Benjamin Franklin and his parodies. Okay, so let me skip that paragraph. And a parody need not spoil its own punchline by declaring itself a parody. Parody serves its goal whether labeled or not, and there's no reason to require parody to state the obvious or even reasonably perceived. And then we go on. The law of parody does not require us to strain credulity so far. Sorry. Some of the words they use in these opinions are just above my pay grade. That is not because everyone always understands the joke. And that is not because everyone always understands the joke. Sorry. Instead, the test for parody is whether a reasonable reader would have seen Novak's Facebook page and concluded that the post stated actual facts. Okay, so you understand that? That's almost a kind of a reversal. It's like, if it's a parody, if you're making a joke and making fun of it, and then it says, well, would a reasonable reader conclude that that was really a fact? Our nation boasts a long history of protecting parody and satire. From the early cartoon portraying George Washington as an ass down to the present day, satirical cartoons have played a prominent role in public and political debate. And parody, like all protected speech, need not be high-minded or respectful to find a safe haven under the First Amendment. All right, now, and I just knew in my small little old brain who's lived several decades as an adult already, I just knew that at some point, Facebook was going to face the same analysis as political satirical cartoons. I mean, those of us who used to really read the newspaper, we used to look for the cartoon satire all the time, and they were pretty aggressive, many of them. They made fun of politicians. They'd show aggressive acts, and they were political cartoons. They were satire. They were a parody. All right, I'm going to go on here a little bit. I'm going to leak up here. Okay, so, and then it kind of, the summary of this opinion, though, is that whether or not it was a parody is a question of fact, not a question of law on his particular post, so it would have to be determined by the jury. All right, then, and then it goes into, and I'm not going to spend my time to go and do a lot of the discussion about the retaliation versus probable cause argument. That's a little high-minded, and I think it would be a little confusing to you. Okay, let me see. Just give me a second. Let me see if there's anything else in here I want to share with you. I just love this opinion. Oh, okay. So there's another issue in here. It's called prior restraint. This is also a very important constitutional issue. Prior restraint. Remember those two words. You need to know how to use those two words. A prior restraint is a administrative or judicial order that forbids protected speech in advance. An action taken after the speech is expressed, like a punishment for disfavored speech, is not a prior restraint. Admonishing the courts not to blur the line separating prior restraints from, subsequent punishments for speech. The First Amendment guarantees greater protection from prior restraints. Indeed, we generally presume prior restraints are unconstitutional. So when they tell you that you cannot speak, that's a prior restraint. The question is whether Novak had alleged a prior restraint. Okay, so it's kind of questioning his whether or not his complaint was sufficient. In light of our long history guarding against prior restraints on speech, we should not be overly formalistic in defining what counts as an administrative order. But courts have not always been clear about what counts as an administrative order, and that poses a problem when we are talking about what is clearly established. That case, in Alexander, the case held that the prior restraint must raise a legal impediment to speech and describe the classic examples of prior restraints as temporary restraining orders, permanent injunctions, and court orders. But the formality of these classic cases should not be a sufficient condition for prior restraint and not a necessary one. Although not in form of a classic prior restraint, the application of a forfeiture statute here bears a censorial cast. A government official should not have to declare his order official or jump through certain procedural hoops to create a prior restraint. Such a rule would allow government officials to cloak unconstitutional restraints on speech under the cover of informality. To borrow a concept, when an officer carries a badge of authority of government and represents it in some capacity. Okay, hang on. All right, so the taking down. Okay, it says, and because the taking down the Facebook page would mean Novak would no longer post critical comments about the police on his page, the letter and the email to Facebook by the police could be administrative orders that constitute a prior restraint. Okay, so what they're saying here is when the police department discovered the fake page, they sent a letter to Facebook and told Facebook to take down the page, and they didn't do it. This case is saying that that is enough. That's enough because it was an official and it was a threat to take down the page. That was enough to create an unconstitutional prior restraint. This is such a great First Amendment case. I love this case. If you probably need to go back and watch this video again and listen to it, and if you're really brainy and you really want to get down to the legal details, you can pull the case up. I'll give the site again at the end of this. But this is such a good case for all the people out there who are gagged, told to shut up. You can't talk about your case. You can't talk about your family. You can't talk about your kids. You can't talk about what a bad job DCS is doing. You can't talk about how frustrated you are with the process of the juvenile court system, or how permanency plans are going, or how meetings are going with DCS, or foster care review board meetings. All those people who put themselves in the area of public service have the right to be criticized because they are representing government factions, right? Okay. Prior restraints. If you go to a perm plan meeting or a chintz meeting or whatever, and they say you can't talk about it outside of here, you can say, I can talk. I have my constitutional right of First Amendment, and I'm going to talk about what I need to talk about. And there's several reasons that I may need another opinion on it. I may need people to know that things are going on here that have not been expressed. Now, you need to be you need to be sure that you're being, of course, respectable, and you're trying to achieve something here. I mean, don't just be mean to be mean. That's not going to get you anywhere. Trust me, in 25 years of practicing, I know people are just mean to be mean, and they just cause obstacles, and it's not going to work, okay? These are critical issues. These are issues related to your children, okay? We have got to crack the barrier on this, and then people who that need help can get real help. Children who need help can get real help. But that 65% in there of kids that end up in the foster care system that there's other options for, though, that's a whole different story, okay? Those are the barriers that we need to break. We need to break the barriers of relative placement, et cetera, et cetera. They're not disclosing it. They're not following policies. They're not following procedures, et cetera, et cetera. All right, so this prior restraint claim, First Amendment retaliation, prior restraint, so important. Watch this video again. Get a little piece of paper or drink your coffee in the morning when you get up and make a few notes about it. Can they tell me when I can't talk, when they can't talk about my case? Okay, hang on here. So, hold on. Let me see. Novak plausibly alleges that the officers created prior restraint with their press release threatening to take legal action. So just threatening to take legal action. And I know I know of a situation in which this was done, actually. Woo. Under Bantam Books, a threat of prosecution can trigger a prior restraint, even if the threat is non-binding. True, the facts in Bantam Books were more extreme than one we have here. There, Rhode Island created a very eerie titled Commission to Encourage Morality in Youth to Investigate Obscene and Impure Literature. The commission sent notices to publishers saying certain books were too objectionable to sell and that violators may be prosecuted. Ooh, wow, that is really some censorship. Police then visited the publishers' book distributors to see if the objectionable books had been removed. But the facts of Bantam Books need not be perfectly analogous for the rule to apply. Rather, we need more facts to determine whether the facts in this case are close enough. So, in other words, the dismissal gets reversed on that as well. The additional First Amendment claims. Novak argues that when the officers Riley and Connor deleted comments on the official Facebook page, they unlawfully censored speech in a public forum and violated his right to receive information. These claims fail because they are not based on clearly established law. The First Amendment no doubt applies to the wild and vast democratic forums of the internet. Ooh, that was just decided 2 years ago. But when it comes to online speech, the law lags behind the times. Very important, and rightly so. The forces and directions of the internet are so new, so protean, and so far-reaching that courts must be conscious that what they say today may be obsolete tomorrow. Oh, yes. Oh, yes. It's so true these days. Courts have not reached consensus on how First Amendment protections will apply to comments on social media platforms. So far, courts have considered the issue, have taken different approaches. So there's one case in Kentucky that denied preliminary injunction regarding the deletion of Facebook and Twitter comments in a case of first impression. Another case held that the government official violated First Amendment by banning a critical constituent from his Facebook page. No doubt, any right Novak or the commenters may have to post or receive comments was not beyond debate at the time the officers deleted the comments. So they got immunity for those claims. All right, then it talks about anonymous, and it says the right to speak anonymously is deeply rooted in the American political tradition and in the First Amendment doctrine. So although, I don't use a fake account under Facebook and don't really hide my identity. I mean, it's basically kind of saying if you create a fake account that's not really new and you make comments about the government, then you're protected for those rights as well. From Thomas Paine's Common Sense to the debates between the Federalists and the Anti-Federalists during ratification, anonymity was core at the founding. When some Federalists encouraged newspapers to ban anonymous speech, the Anti-Federalists defended their right to remain anonymous, okay? Making anonymous criticisms of your government is a First Amendment protection. Free speech was originally understood to include the right to speak without being known. Consistent with this original understanding, the Supreme Court has upheld the right by striking down laws banning anonymous speech. This is interesting, but Novak is not contesting a law or policy that bans anonymous speech. Instead, he argues that the police officers disclose his identity as part of their criminal investigation. Yet he has pointed to any law clearly establishing that investigative actions by police can violate the right to speak anonymously. Investigations are often public events, and so are criminal trials. Well, however, you have to think about it. His whole criminal trial got dismissed, and so he would have been able to remain anonymous had they not created the illegal criminal trial. That would be my argument, but they didn't go that far. The Supreme Court has recognized that courts can reduce a criminal's trial's publicity, but only under the right to a fair trial, not under the right to remain anonymous. Yeah, but like I said, they wrongly created the case in the first place, and there's a lot to be said about that. It's not clearly established that announcements made in an ongoing criminal investigation can violate Novak's First Amendment right to speak anonymously. The officers are entitled to qualified immunity. Okay, so then the illegal search and seizure. Novak alleges that the officers unlawfully searched him and seized his property. He alleges wrongful arrest and malicious prosecution. These claims survive as well at this stage of the litigation. Ultimately, Novak will have to show that the officers lied to get a warrant for unlawful seizure or lied in the course of his prosecution for malicious prosecution. Novak will have to make this showing in light of the Ohio statute that grants broad discretion to officers. To prove malicious prosecution, Novak will show, 1, that the officers' deliberate and reckless falsehoods resulted in arrest and prosecution without probable cause, and 2, that the officers did more than passively participate in the decision to prosecute or keep prosecuting him. Novak must also show the absence of probable cause. Usually a warrant from a neutral magistrate, like the ones Connor got in this case, would be a complete defense to a 1983 claim. Not so here. Warrants are typically a defense because they demonstrate probable cause. But warrants do not demonstrate probable cause if the officer made false statements and omissions to the judge. If probable cause would not exist but for those false statements and omissions, bingo, we're going to